Okay, welcome everybody, or welcome back to the University of Michigan Concussion Center Speaker Series. My name is Steve Broglio, and I'm the director of the center. I'm happy that you're able to join us today. We have an exciting presentation. A couple of housekeeping items just before we get started. The session is being recorded today, and it'll be available on our website probably next week at concussion.umich.edu, so feel free to check it out. And then after the presentation today, there's going to be a few moments for questions. So for those of us in the room, feel free to shout out. Or if you're joining us online, please type your questions into the Q&A section at the bottom of the screen. Over the years, I've had the great pleasure of getting to know some of the world's leading experts, concussion providers, concussion researchers, and concussion advocates. So the goal of the speaker series is to bring those people to you so you can learn from our colleagues from around the world. I'd like to give a warm welcome and special thanks to two of our guests today. First is Dylan Henry. He's a partner at Montgomery McCracken's litigation department. He also counsels individual schools, organizations, and on catastrophic sports injury matters and the proper management of sport-related concussions and sport-related injuries and TBI. Kacie Kergides is an associate at Montgomery McCracken's Sexual Misconduct Liability Practice Group and a member of the Catastrophic Sports Injury and Defense Practice. And today they're going to give us an update on concussion and CTE litigation. I'll let you guys take the floor.
Thank you, Steve. And I'm going to get the slides sharing. Yes? Yes?
Yeah, we can share.
Screen 2. There we go. All right, thanks, Steve. As Steve said, my name is Dylan Henry. I'm a partner at Montgomery McCracken, co-chair of the firm's Catastrophic Sports Injury Defense Practice Group. And in that role, we advise, defend, represent institutions and individuals in catastrophic sports injury defense matters from heat stroke to TBI. My partner and mentor, Steve Packman, who's here with us today, he founded this group, and he's been involved in some of the more watermark seminal cases for over the last 20 years or so. And as Steve said, we're here today to talk about concussion and CTE litigation and some trends that impact you all as medical providers, current trends, and some trends that, reading the tea leaves, we kind of see where they're going to be going in the future. And so without further ado, I'm going to kick it off to my colleague Kacie, who's going to let you know where we're going and kind of lay some groundwork that's necessary for the conversation that we're going to have today.
Hi, everyone. It's great to be here with you all. As Steve and Dylan said, my name is Kacie. I'm a member of our firm's Catastrophic Sports Injury Group, as well as our Title IX Sexual Misconduct. And I promise I won't talk about that stuff today because it could be a whole another day's worth of a presentation, but we're going to be talking about catastrophic sports injury first. And it's great to be here with you all. We've been here the past several years. We've always come to teach Dr. Broglio's undergrad and grad students, but this year we got called up to the A squad and got to talk here with you all today. So going through today, we're going to be touching on Litigation 101, and that is something that takes a whole semester's worth in law school, but we're going to go through it quickly here because it provides a great backdrop for the lawsuits that we see, and we think it's important that you guys understand what are the underlying causes, claims of these lawsuits. Next, we're going to be talking about the evolving standard of care and the updates to the evolving standard of care, because that's pretty much why these lawsuits are so voluminous. We'll also talk about CTE in the law, the unsettled science, the untested theories, and the legal implications, and then we'll end with the litigation trends that we're seeing 2023, 2024, and beyond. So, Litigation 101. The two main questions we're always asked are, who are the defendants and what are the claims and theories? So for the defendants, unfortunately, the answer is everyone is a potential defendant. And in these lawsuits, whether it's second impact syndrome, concussion, CTE, failure to return to play or premature return to play, the primary target are the athletic trainers and the doctors because they are the main points of contact with these athletes when these catastrophic injuries occur. Divisions, schools, athletic directors, they're also main targets, but the universities and the conferences sometimes, or excuse me, the public universities are protected by certain privileges. But the main issue for conferences in the NCAA is do they owe a duty to these student athletes? And I'll talk about more duty later, but ultimately in these lawsuits, everyone is a potential target. So what are the claims that we see? The main claim that we always see is negligence. And negligence is a 4-element claim. You have to prove duty, breach, causation, and damages. So the plaintiff, who's the person bringing the lawsuit, needs to argue that the defendant owed the student athlete a duty. The athletic trainer, let's say, breached that duty. That breach then caused the damages. Duty and damages, the first and fourth elements, are really easy to show. It's pretty well established that an athletic trainer, an athletic doctor owes the student athlete a duty of care. Damages, again, pretty easy to establish because there really wouldn't be a lawsuit if there wasn't damages. There's a catastrophic injury. Damages are pretty easy to point to. Breach and causation are what we call the legal battleground. That's a lot harder for the plaintiffs to prove. And that's where we come in as defense counsel to try to defeat the case there. That's really where these lawsuits live and die, in the breach and causation elements. So what is negligence? Negligence, by definition, is the failure to conform to the standard of care that a reasonably prudent person would have exercised under similar circumstances. So if you are an athletic trainer, if you are a doctor and your case goes to trial, the ultimate question is, what would a reasonably prudent athletic trainer, doctor, would have done under same or similar circumstances? So you're comparing what an athletic trainer in a women's soccer game would have done in an athletic trainer in a women's soccer game. You're not comparing how would an athletic trainer for Michigan football reacted in this situation, because it needs to be the same or similar circumstances. And even get so granular as you're not going to compare what a Michigan football athletic trainer would have done to a D3 football athletic trainer, because resources are different. So we really focus in on the same or similar circumstances, and it's what a reasonably prudent athletic trainer, doctor would have done. So the main allegations are that we see are failure to warn, educate, or train, premature return to play, mismanagement, misdiagnosis, failure to evaluate, test, or monitor, and failure to refer. So for example, failure to refer, and it would be if an athletic trainer failed to refer a student athlete to a doctor for clearance following a concussion. For example, in the CTE cases, we see the main allegation is failure to warn, educate, and train, being that the NCAA knew about the issues of subconcussive blows and knew about it for years and failed to train, educate, and warn the student athletes. The evolving standard of care. This is where these lawsuits live and die. The legal implications of these evolving standards of care is that it's easier for plaintiffs to bring and maintain these lawsuits. And on the flip side, it's harder for defendants to conform to the standard of care because it's constantly evolving. We always refer to it as a moving target. It's shrinking, it's growing, it's moving left, moving right, constantly changing, making it hard for defendants to conform to that standard of care. We're not going to go through all of the history of the position statements and white papers, but this is where the standard of care comes from. These position statements that are published. Most recently, we've had the 2019 AMSSM statement. We've had the 2023 Amsterdam statement, which is the most recent. And then hot off the press coming in 2024 is the NATA bridge statement on concussion care. So these are where the standards of care are established in these position statements. And Dylan is going to talk about the most recent one.
Thanks, Kacie. And I can. Yeah. I'm sure most of you in the room and online know that this summer, the Concussion Sports Group issued what is now the most recent consensus statement on concussion in sports. This supplements and enhances what was the Concussion in Sport Consensus Statement, the 5th edition from Berlin, 2016. So it was 6 or 7 years in the making, but good things come to those who wait. I think COVID threw some wrenches in the works. But here we are. And from a legal perspective, from a lawyer's perspective, this sets the bar. This is the gold standard document. This establishes the standard of care for concussion prevention, treatment, and management. Of course, if you read the document, there's a disclaimer, probably from the encouragement of a lawyer, that says this document does not establish a standard of care from medical legal perspectives, but that falls deaf on plaintiffs' ears. This will be shown to defendants, right? So I wanted to go through just some high-level takeaways from a lawyer's perspective. I would encourage everybody to get very familiar with this document, know the research that this document summarizes, but let's just go through. So we now have refine and retire. The previous statements had 11 R's of concussion. We now have a baker's dozen. 10 years from now, we're going to be talking about the 57 R's of concussion. I really want to focus on the retire aspect. We now have, formalized in this consensus statement, a whole section attributed to retirement from contact sports. And so what this is the conversation with the student athlete as to when to discontinue participation or retire from contact sport. I'm sure a lot of athletic trainers, team physicians are already having that conversation when the situation warrants it. But now that it's formalized, it's really making sure that your policy matches your practice and that you have policies that discuss this retirement conversation. One of the bigger updates and kind of the easier to digest updates is a move from a SCAT-5 sport concussion assessment tool, CRT-5. The pocket assessment tools have been updated. We have the SCAT-6, the CRT-6. There's now office assessment tools. The takeaway, it's not the nuances between a SCAT-5 word list and a SCAT-6 word list. The takeaway from the lawyer's perspective is if you have policies that are referencing SCAT-5 or that are tracking the modalities of a SCAT-5 analysis, either from the baseline or for evaluation, it's low-hanging fruit. It's a dangerous game from a liability perspective because just on its face, it appears that you're not compliant with what is arguably the standard of care. If you're handing out a CRT-5 to a coaching staff, knowing that there's a CRT-6 out there. So update policies accordingly. Active rest, long gone are the days of sitting in a dark room doing nothing. Rest does not appear in most cases to be beneficial. The consensus statement based on the research is that a return to light physical activity that doesn't exacerbate symptoms is good for not only shortening the symptoms, but also kind of getting back to a full recovery. The return to sport, we're all familiar with that from previous physician statements and practices, but the Amsterdam statement has more specific, sport-specific, individualized return to sport protocol. CTE is finally, Berlin referenced it and talks about it shortly. There's now a whole section on CTE. The research is summarized as follows. We don't know, the prevalence of CTE. We don't know what CTE causes or what CTE causes or what causes CTE. We don't even know if CTE is progressive, right? So it's important to see where that develops and how that evolves throughout the next couple position statements, and when they meet again, the concussion sport group meets in the next few years. Prevention, again, that reduce our, there's good research now, reducing full contact practices, certain use of PPE, personal protective equipment, training, strengthening to potentially reduce concussion. Again, all of this is to make sure your practices and policies are jiving with what is the standard of care to avoid liability, right? It's like health, safety, and welfare of the student athlete that greatly overlaps with what we care about as lawyers is like mitigating risk, but making sure that your policies and practices jive with what is arguably the standard of care. One thing I wanted to talk about, return to driving, and I was discussing this with Steve Brolio. The Amsterdam statement's silent on that. The 2019 AMSSM statement has a whole section regarding return to driving. It points out that there really isn't a widely accepted return to driving protocol. Most clinicians don't have that conversation, and it's pretty easy to see that story play out in court. You had a student suspected concussion, diagnosed concussion. You didn't talk about driving at all with them. You didn't document the conversation about driving. There's a car accident. You can see that play out. So I understand that the 2024 NATA bridge statement is going to actually discuss a return to driving, either return to driving or have a protocol in place. But it's just interesting that to point out and to see if you are having those types of conversations with your student athletes. And Kacie's going to talk about some questions that we typically receive from our clients.
So with the evolving standard of care, we're often asked tons of questions, and we've kind of boiled them down to the main questions we're always asked. So what are the latest updates? There are so many position statements. You saw that slide up there. Which one should we follow? Which one should we read? And without, our answer wants to be all of them, we recommend the ones in the past 5 years, because the ones that you don't read, the ones that you aren't aware of, are the ones that the plaintiff's lawyers are going to point to and say, you didn't do this over here. And we can't avoid that. And it's hard to cross every T, dot every I, but you want to be aware of them and you want to know, and we recommend the ones in the past 5 years. Other questions are often asked, is neuropsych testing required? What about documentation? How do we document? Do we have a duty to preserve our documents? What if one of my players suffers a concussion and then leaves my team? Do I have a duty to follow up? If so, for how long? Is the SCAT-6 required? What if our policies, we have the SCAT-5, now SCAT-6 is out there, do we have to do that? These are all questions we're asked. And it's, like I said, the one thing that you don't do is what the plaintiff's attorney is going to point out and harp on over and over and over. And there's no avoiding that, right? But it's what can you do to lower your risk and mitigate your liability going forward in these lawsuits. So, as I said, the standards of care, there's so many position statements out there. What should we do? What is something we have to do? So we've boiled it down to a few bullet points of our musts that we like to talk about. One is have a written concussion management plan on file. And if you have that on file, which you must, follow that plan. We've had instances where our clients have a certain baseline testing in their policy, but when it comes to actuality, they like to do this one over here better. Well, there was a lawsuit and said, well, your policy says this. And you could get up on that stand and say, yeah, but we know this one's better. But, you're looking down a barrel of a gun when they're saying your policy says this and you did not follow your policy. So if you have what your concussion management plan says, follow that plan. And if it's an outdated testing that you no longer do in practicality, update that policy. It's simple, but a lot of times in actuality, it doesn't happen. So make sure you do that. Next, we always talk about evaluations by a medical staffer with concussion experience. So we hope that, the coach isn't, someone goes down in a game, the coach isn't going out there and saying, oh, no, athlete's cleared, we're good to go. Make sure that it's someone with concussion experience. It seems obvious, but like I said, in practicality, it's not always what happens. Should be black letter law these days, no same day return to play for a diagnosed concussion. In the same vein, athletes cleared by a physician with concussion experience. And the last bullet point is acknowledgement. Have your student athletes, and we know it's an NCAA requirement that they sign the papers and the attestation forms, that they were educated on, the concussion symptoms and things like that. But student athletes, as a former student athlete, you could have thrown any paper in front of me and I'm signing it just so I can run out to practice and make sure I get on that field. So take the time to sit with the student athletes. Take 5 minutes. They may not listen to what you're saying, but that way when you're on the stand, you can say, I sat with this student athlete, and document that you sat with that student athlete and explain to them. I walked through the form with them. I explained the risks and what happened and the importance of reporting what they're feeling, the injuries that they're feeling, the pain that they're feeling. And that way, again, mitigates your risk and mitigates your liability.
Right. And like lawyers love documents, right?
Yes.
We love documents.
Hence the next slide.
Correct.
Documentation. So document all information purposefully, right? Make sure, because when you go, when the case does go to trial, there is a lawsuit, you're going to be thrown in front of you what you put down on paper. Do you want, you want to make sure what's put in front of you and what's read to a jury is purposeful. You don't want, I think she was all right? You wanted to make sure that it's purposeful documentation. Document all your communications with the athlete. Document the things that you see, but the things that you don't see, right? So make note of what signs and symptoms the student athlete is not displaying. We always live by the adage, if it's not documented, it didn't happen. One other bullet point that I always like to talk about, we don't have it up on the slide, but I think, as I said, I'm a former student athlete. One thing that I always like to talk about with athletic trainers and doctors is building a trustful relationship with your student athlete. And I know it sounds so obvious, but athletes lie. Athletes will hide their injuries. And yes, sometimes it's much easier to hide a concussion or the pain levels that you're feeling than a sprained ankle or whatever it may be. And because the student athlete, all they want to do is get on that field. And they are so afraid that if I show any vulnerability, if I say I'm feeling a little bit of pain, that means I'm going to sit out of practice, which means I'm going to lose my starting spot on Saturday, which means I'm going to ride the bench for the rest of the season. I'm losing, it's done, my career is over. And it's that quick of a spiral for a student athlete. I give this talk all the time. I'm in my 30s. I tore my ACL last year and I didn't want surgery. I don't play soccer anymore. It was the 11 game, didn't even touch the ball. Don't even talk about it. But I couldn't drive because it was my right knee. So I go to my husband takes me to the doctor, and I really didn't want to get surgery. I've already been through it once, don't want to have to do it again. And the doctor's looking at me, he's like, how's your pain levels? Like, can you go up and down stairs? It's totally fine, I'm good. I can go up and down stairs easily. My husband looks at me and is like, Kacie, you've been sleeping on the couch because you're in so much pain. And I'm like, what is wrong with me? I'm never playing competitive sports again. The most I'll be doing is playing in the backyard with my son. But here I am, still in my 30s, lying about the pain because it's ultimately my decision whether or not I want to have surgery, right? This doctor's not telling me whether I have to or not, but I'm still lying about it. So it's this innate thing in student athletes that they will do whatever they can to get on that field. So you want to form that trusting relationship so that way when you're talking to them, you will say to them, look, hey, if you're feeling that pain or whatever it may be, that's fine. If you can deal with it, go out and play. You're not going to further hurt yourself. Athletes don't think that that's going to happen. They, like I said, they think you disclose any bit of vulnerability, any bit of pain, and their career is entirely over. So you want to build that trust with the student athletes. And I think it's so important because at the end of the day, if a lawsuit does happen and you get up on that stand and you say, you know, they didn't tell me they weren't in pain, I didn't know, that's not good enough because you are the medical expert and you knew or should have known that they were injured or that they were feeling some type of pain or whatever it may be. You are the expert. So it's not good enough. You're still going to be held liable even if they didn't disclose it to you fully.
Right. And the question is, well, what are we supposed to do? And exactly what Kacie said is building that relationship of trust.
Yeah.
Bring it into the concussion realm, right? That's not as easy to do a test to see if you have a good ACL or not, right? It's really hard. And that's why that relationship of trust is really important when it comes to things you cannot see and you cannot really easily diagnose.
Yeah. And it's also one of those where I'm afraid that anything I tell my athletic trainer is immediately going to my coach. And again, it may seem obvious. You're not telling the coach every single thing that we talk about, but the athlete doesn't see that. So building that relationship from day one, saying, hey, I want what's best for you. I want you to be out on that field just as much as you do. And we're going to work together to make sure that you get out on that field and stay out on that field for as long as possible.
That's great. And we're going to shift gears just a little bit now because no concussion talk is complete without discussing CTE, right? So CTE and the law. And what Kacie was talking about is a good framework to understand why we're having this conversation when it comes to unsettled science and untested legal theories. So the unsettled science around CTE, why does it matter from a legal perspective? So we have this spectrum of experts. On the one side, we have experts finding CTE in every brain they review. On the other side, we have experts saying that CTE isn't even a thing, right? So why do lawyers care about that? Well, for the most of us, most experts in the field, maybe some of those in the room, they fall somewhere in the middle. CTE is a thing, it's a syndrome. The CDC recently, started calling it a disease in their white papers. It's a thing, but from a legal perspective, we're not pulling from the middle. We're pulling from this side or that side, depending on if you're a plaintiff. CTE is everywhere for sure. Defense, CTE is not real. But what makes it tricky is, or why does it matter from a legal perspective? So as Kacie said, duty, breach, causation, damages, the legal battlegrounds, breach and causation. So in a CTE case, you have to prove a breach, failure to warn. You failed to warn me that 35 years ago, the exposure to repetitive subconcussive blows would lead to, CTE or CT-like symptoms to develop, which would lead to damages, which in CTE cases with a post-mortem autopsy, death. So there's a lot of causal bridges that plaintiffs need to gap in order to prove their case. And that's where the science comes in. They use experts to bridge those gaps. But what the unsettled science actually leads to, two things. First, it's fear. The media hysteria has far outpaced the science. But also what we care about is litigation, because the unsettled science makes it easier for a plaintiff to bring and keep a lawsuit going through the process, to get over a motion to dismiss, to get over a motion for summary judgment, to get to a jury. And what makes this even more complicated is, well, so who's to decide, right? We have this expert saying X and this expert saying negative X, two completely different things. Well, in a lawsuit, as we were discussing earlier today, it's the 6, 8, 12 random people that get impaneled on the jury. They're the ones who decide. And it could just be based off of, I don't like the way this guy's voice is or the tie he's wearing, but he's the expert opining as to whether he finds CTE or not, right? And Kacie's going to say the wrinkle that makes this even more complicated in the CTE space. Oh, this was interesting. I was doing some research preparing for this. And I came across this 2023 review paper talking about the media presents an alarmist bias view of CTE that influences patients' concerns and outcomes following concussion. And we can talk about this more in some of the CTE trends and the cases we're talking about. But you have suicide notes from these athletes, like tragic situations, saying, "I know I have CTE, and ultimately committing suicide. So please donate my brain." So we're in this kind of Wild West situation right now as it relates to the research. But Kacie's going to talk about. Oh, perfect. So unsettled science makes its way to the court, and this is a great case study. That Todd Ewan, he was a hockey enforcer for over a decade in the NHL, tragically killed himself in 2015. His brain was examined by Lily Naz Hazrati, Dr. Hazrati, and she found no evidence of CTE. 3 years later, the Boston group looked at it and did find evidence of CTE, right? So we have these diametrically different opinions from experts in this realm. So you have this unsettled science, and then you have these legal theories of causation. Kacie's going to talk about what further wrinkle we have in CTE litigation with untested theories.
So we had no data points up until past 2022, the past year, and another one this year, to how are these cases going to play out if it does go to a trial. Everything was in theory. We had nothing to point at. It wasn't until 2018 that these cases finally reached a jury with Plex v. NCAA, but that ultimately settled in 3 days after it went to the jury. So again, we were left with nothing. But then in 2022, a lawsuit was brought. Matthew G. was against the NCAA. He died, and his wife brought a lawsuit against the NCAA for wrongful death. And their claim was he did play football for USC from 1988 to 1991, and they alleged that he suffered 6,000 hits to the head while playing football. And that led to brain damage, CTE, which led to his alcohol and drug use. He died in his sleep from cardiac arrest. And when he died, his blood alcohol level was 4 times the legal limit. And they also found cocaine in his system. So like I said, the plaintiff's theory was, 6,000 hits to the head led to brain damage, CTE, drug and alcohol use led to his death. But the NCAA then started pointing to other things, saying, he was born with a rare disease that caused so much pain that at one point in his life, he asked the doctor to amputate his foot because he was in so much pain. He started drug and alcohol in in high school, and then, while at USC playing football. When he went to try out for the Raiders, he filled out a form, and on there it asked, "Did you suffer any concussions?" Checked no. He had an enlarged heart. He had liver disease, untreated sleep apnea. So all of those other medical issues led the jury to find, we couldn't find a causal link here between all of those subconcussive blows, those alleged 6,000 hits that he took to the head, causing CTE, which led to his death. So that gave one good data point for us. Next, it was, in this past year, there was another lawsuit again, where the jury found for the NCAA. So it just gives us 2 data points that we can now point to. It doesn't mean that plaintiffs can't bring any lawsuits, or they're going to lose every lawsuit that they bring, but it does raise that bar a little bit higher for them that they have to get over now. And I think it does provide us good data points going forward for what is it really going to take for a jury to find for a plaintiff in this? What is it going to take for the jury to find a causal link between football and CTE and believe that the NCAA was negligent or knew about it? And so we're still looking for that, but now we have at least 2 data points that we can work off of and see where it's going to go.
Right. And, some of the experts that I had up on the spectrum slide, they testify, they're testifying experts, they're research experts, but they're also testifying experts, mainly for the plaintiffs. So for the NCAA to get a win, but whether that means they don't owe a duty or that they didn't find medical causation, from the jury, still kind of remains to be seen. But you have these experts giving testimony and the jury finding for the defense. But each case is case specific. And like Kacie said, this isn't going to be going away anytime soon. They're not going to give up. And it really is going to take one case to go the other way for it to like explode gangbusters.
Yeah.
So talking about CTE litigation and staying in that vein, wanted to talk about litigation trends in the CTE world, how they impact you, how, what you should think about, and kind of reading the tea leaves where I think some concussion or CTE litigation could be going. So again, unsettled science, untested legal theories, saving those 2 data points we recently received makes it easier for plaintiffs to bring and to maintain lawsuits. But there's other trends that are kind of expanding the base of potential plaintiffs or increasing the amount of damages that could be alleged. So we're seeing older and older injuries. If I hit you, let's do it that way, not you hit me. If I hit you with my car, sorry, but you have 2 years, plus or minus a year, depending on the state, to sue me. That's a statute of limitations, right? You're injured, you have 2 years to sue. If you don't, you are forever time barred from doing so. That's the way the law is. In the CTE cases, we're seeing hits from the 60s and the 70s. So how does the statute of limitations come into play to that? The defense will use that. It's one of the first defenses that they will use to varying degrees of success. The Schmitz case is a good case study of how that comes into play. The NCAA argued, hey, your claims are time barred. Schmitz played for the Fighting Irish back in the 60s or 70s, I believe. They didn't start exhibiting CTE-like symptoms until 2012. Sued in 2014 when he was still alive, alleging he had CTE, and then tragically passed away in 2015. The lower court said, yeah, these claims are time barred. No. It made it up to the Ohio Supreme Court. And for the first time, the first appellate court in the country said that brain injury related to football could be latent, which meant the case could continue. And it had to do with when he first exhibited symptoms or was first diagnosed. Again, I think this is still the only appellate court decision holding that brain disease might be latent as it relates to football-related brain diseases. But if other courts follow suit, the potential for plaintiffs' older and older injuries has the potential of, again, going gangbusters. And taking that theory, a plaintiff playing today, a college football athlete playing today, or any athlete, in 2023 could bring a lawsuit in 2060, right? So why is it important to document? I don't think you're going to remember what's going on in 2023, 35 years from now. So again, that's a trend that we're continuing to watch, and it's not going anywhere. We're also seeing lawsuits brought by younger and younger athletes, or on behalf of younger and younger athletes, because again, in all of these cases, it's death, right? So CTE is postmortem, autopsy, diagnosis. The Pop Warner and Riddell helmet cases are good examples of just younger and younger athletes bringing these lawsuits. They all played football in the 90s or the early 2000s. They all tragically passed away in their 20s from drowning, motor vehicle accident, drug overdose, suicide. Again, younger and younger athletes, we have the opportunity of expanding that base of potential plaintiffs. Just this year, the Boston group, I don't have it up there, the Boston group had a study. They looked at like 152, say 150 brains of student athletes that played contact sports, all died under 30, mostly male. And they found CTE, evidence of CTE in 40% of those brains. So again, this trend is going in one direction on the graph. Another trend, CTE in the living, the Schmitz case that we talked about is an example of that. But Dr. Malu's part of a team that's trying to perfect diagnosing CTE in the living through different, stains and dyes and different imaging. Again, why does this matter from the litigation perspective? Also, we have the diagnostic criteria from the NINS, the Neurological Disorder Stroke Consensus Diagnostic Criteria. That's for the clinical disorder, traumatic encephalopathy syndrome, which is arguably, is that related to a CTE pathology? Diagnosis is important for, treatment and prevention. From a legal perspective, what I see is a living plaintiff is a much higher demand calculation because you have years and years of life care plans, years and years of neurological decline. So the value of those cases are going to increase the more living plaintiffs we see, whether it is an allegation of I have CTE and I'm still alive, or I have TES. I have alerts set up for lawsuits that are alleging traumatic encephalopathy syndrome. I haven't seen many, but reading the tea leaves, I think that we're going to start seeing more. And along the lines of diagnostic tools, we're often asked, isn't this like, can't you just do like a cheek swab or something? Isn't it easy? Like, can't you just do blood test, 10 minutes, yes, no concussion? How do these concussion diagnostic tools come into play? They say concussion's a snowflake, everyone's different. It's not binary, it's a cluster of diagnoses. It requires a clinical diagnosis from a clinician who has experience in diagnosing concussions. So, don't believe the headlines is what I tell the clients. There is a market out there. We have the biomarkers, saliva, blood, neurological signals, EEG tech. There's an FDA-approved ocular screening device. We have impact force detection devices. If it's red, check your head. A little force vector type device you just put on a helmet. But again, the message here is you cannot, whether it's a diagnostic tool, an assessment tool, rely on one tool in a vacuum because it's a cluster of diagnoses. And we do get a lot of questions about prevention devices and the standard of care. Like, what about the Q collar? Do you need to have all of your players wear that Q collar to the extent that nobody or you don't know or are not familiar with the Q collar or similar devices, something that kind of increases, I think, the interstitial pressure. I'm not sure how it actually works, but you wear it around your neck. You'll see it on TV sometimes. Some players will wear it. But do you need to hand those devices out to every single player to meet the standard of care? I don't think the evidence is there yet. But as Kacie said, it's evolving, and the research is always evolving. So you have to stay up to date on everything in order to meet the standard of care. Had to bring this to everybody's attention. Just this summer, the Concussion Legacy Foundation and the Boston group put out what is a CTE prevention protocol. You can look that up if you want. I think we all agree that reducing the intensity of hits or reducing the frequency of hits to the head, or even increasing the age that you're first exposed to concussive blows, it's probably all a good thing just for like health, safety, and welfare. But the question of, well, okay, I saw this. Do I need to have a CTE prevention protocol in place now? I don't think the evidence is there yet, but kind of stay tuned and continue to monitor like what the research, those of you in the room, those of your colleagues, what they're doing, and where's it going. I always think this is interesting, and this was like one of our first data points, the Matt Onishko case. So we didn't really have any data points on CTE directly, but there has been lawsuits, and the Onishko case is one of them, where the allegation is your failure to warn about repetitive subconcussive blows led me to develop X neurological disease. And in this case, it was ALS, Lou Gehrig's disease. And this was like the first jury verdict in this whole realm of brain injuries, where the NCAA got a defense verdict from the jury. They appealed, the appellate court agreed with that verdict. But again, trends that are expanding the base of plaintiffs or expanding the type of claims. This is a good example of one of them. And Kacie, is going to talk about increasing damages here.
Right. So Dylan talked about the increased pool of plaintiffs, and that's growing now. One other thing, we haven't quite seen it, but we're predicting it, right? This section is litigation trends that we expect to see in 2023, 2024, and beyond. But a lot of these student athletes, as I'm sure you're all seeing, especially being at the University of Michigan here, they're getting NIL deals for millions and millions of dollars. So does that increase the value of a student athlete now when a lawsuit happens, right? Is the damages amount going to be that much higher because of the value of that student athlete and the money that they could make off of NIL deals? Are those marketing and sponsorship deals increasing the damages? We haven't seen it come into play, but it's something that we're predicting and think that will happen. Also, now that student athletes have agents because of these NIL deals, what happens when an agent and a student athlete comes in and says, hey, if I'm not playing on Saturday, I lose my $20,000 deal with the car dealership down the road because I'm not wearing this shirt during warmups or whatever it may be. I'm losing out. You're causing me $20,000 because you're holding me out and won't let me play in this game. We help and we recommend and say, that doesn't matter. Medical doctors still need to clear you. But these are all pressures now that are going to be put on organizations, teams, schools, doctors. And it's just things that we're looking at, seeing things that are growing in these student athlete hemisphere that's going to increase the damages pool for these lawsuits as it goes forward. And like I said, we haven't seen it come into play, but it's something we 100% think will come into play, right? The damages are going to now increase because those student athletes are worth more. They're worth more. So,
and it's interesting because Kacie went through what we typically see as like the theories in these cases, premature return to play. But with NIL and the money on the line, the question is, well, you failed to clear me to play because I have independent medical saying I'm ready to go and you're not letting me go and you're hurting me financially. That's why you should have a really good policy in place that discusses, who has the ultimate authority and autonomy to clear the student athletes to return to play, notwithstanding any sort of independent, extrinsic interference, clearing an athlete or anything that contradicts what the independent medical of the team says. All right, so in conclusion, how does this impact you? What can you do? And, it's kind of like what we tell our clients. It is and will continue to be, notwithstanding all the great research everybody in this room and online are doing, it's right now, and again, until we all can agree, it is the Wild West, right? So you got to control what you can control. You can't control unsettled science, notwithstanding the research, doing a great job. You can't control untested legal theories. Cases settled, they don't go to a jury. You can't control that the base of plaintiffs is expanding or that it's easier for plaintiffs to maintain a lawsuit. So what can you control? What did we say about 1,000 times today? Check your policy. Make sure you have a policy. Make sure you're following it to a T, because if you don't, low-hanging fruit. In light of the ever-evolving standard of care, continue to audit that policy, stay up to date on all the research, and rinse and repeat. We're here for you. We're a phone call or email away. We get questions all the time in a lot of spaces, like I said, from keystroke to TBI. But we also have our game plan, which we put out, on a frequent basis, which brings a legal perspective to what's going on in the concussion CTE world, but also in the sports litigation world generally. So thank you all for having us. I would love to answer questions so we can have a conversation.
Kacie, thank you for that great presentation. So we have a couple questions here from our online audience that I can start working on while people in the room are thinking about their own questions. The first is, what defines a staffer with concussion experience? I think what they're getting at is many of the consensus guidelines recommend a qualified healthcare professional with concussion experience. So I think the question is, what defines concussions?
That's a good question. You want to take that? Okay. I mean, all right, well, what's the standard of care? We all just crushed 15 weeks of torts in like 30 minutes, right? So you're all like kind of a 1L lawyer. A reasonably prudent what? Like a reasonably prudent person. So what does the University of Michigan have in their policies for clearing that? I would think it's the athletic trainer. Is it a student or the grad students we met with yesterday? Probably not. I mean, would you feel good going into court saying, yeah, we had our grad students clear these guys to play. They got hit in the head and now they're dead. Right? So I would think, athletic trainer who's under the direction of a doctor, all with experience of clearing somebody with a concussion or diagnosing and monitoring of them.
All right, great. We got another one here. Is neuropsychological testing recommended to prevent liability?
It's an interesting.
Going over this.
You can go ahead.
No, I was going to say it's an interesting question because I think the position statements sometimes are starting to pull away from it, is our understanding for neuropsych testing. But if some require it, and it, give the lawyer answer, it depends. What's that?
What type?
What type, right? What type of neuropsych testing? It's in your policy. Follow it. Right, and then look to see as the science is evolving, update it based on what the most recent position statements say on it.
Yeah, like not to call out any one particular type of testing, but some evidence suggests that some testing is no better than a flip of a coin, right? And if you're just relying on that, are you doing a disservice to the health, safety, welfare of the student athlete? I.e., from my point of view, are you kind of exposing yourself to liability? Again, kind of make sure your policy is up to date with what is suggested. Amsterdam does discuss baseline testing, and I think it's what, as resources allow or where possible. So again, if you're talking about a D3 club program versus a D1 elite program, it kind of depends on case. but if you can, you probably should. But again, you have, a lot more area for somebody to look at and say, well, all right, you have this baseline test, which asks for this, you're supposed to use the balance error scoring system on a mat. Did you? So there's a lot more things that you could look at and nitpick too.
All right, great, thanks. Another one from online. Now that the scope has been developed and is in the consensus statement, should we be using this in concussion clinics?
What scope?
Scope.
Oh, scope. I'm not a doctor. I'm not going to tell doctors how to do their job. Like that's what I'll have meetings, counseling with organizations that have a assigned doctor, and it's always like this awkward dance. Like, hey doc, like I'm not asking you how you do your job because I don't have a medical license, but are we doing something close to these? We got some buckets. We're checking all the boxes in these buckets. I mean, I think that's if you don't have something in place already, I wouldn't even say that. Even if you have something in place already, look at the scope and see what modalities it's following, and making sure you're kind of matching your practice or whatever your policy is to that.
And I think it's the same thing if resources allow, right? If you have the resources to do it if it's in the answer or in the most recent one, right? Like that's what we say, try to stay up to date, and if resources allow, probably should do it.
That gets tougher though when you have doctors, right? And healthcare system, because SCOT's office assessment, you have a clinician, it's all you care about, right? It's fulfilling your duty to that patient. So it's hard. Yeah. Imagine sitting there being you didn't have enough money to do this or that, and you have a dead student athlete and a jury that's there to kind of judge liability.
Another one from online. Today, with all the news and public information available about CTE dangers in football, is it reasonable to assume that the average and reasonable athlete should know the dangers of playing football even before they are educated by a team?
That is something we always talk about, right? So you go ahead.
I was going to say, I always talk about how we thought these CTE lawsuits were kind of going to be time barred by certain things, because starting 2005, 2008, CTE is, as we put up on that slide, everywhere in the media. You turn on, NFL, you turn on ESPN, whatever it may be, you're seeing CTE everywhere. So is there assumption of the risk, which is a legal theory that now you're saying student athletes, these athletes knew the risks of playing football could lead to brain injuries, traumatic brain injuries, whatever it may be. But now we think, it's gonna, just when we think we're kind of limiting that in scope, student athletes assumption of the risk, you got out there and played, you knew what the risks were. So now I think it could expand into plaintiffs' lawyers are very creative, saying, okay, but did you talk to the student athlete about, you had 4 concussions, maybe you should retire now. Did you have that? Student athlete's going to say, no one talked to me about that. I didn't know that the 5th one was going to, put me over the edge and whatever it may be. Or in these CTE cases, the wife is going to be on the stand saying, no one told my husband that. If someone told my husband that, that 4 was too many, he should have retired, he would have retired, right? So I think these theories of liability, just when you think they're time barred with assumption of the risk, it's going to branch off into something else.
Right. Yeah. And it's hard to argue. I didn't know playing football would expose me to concussion, right? It's inherent in sport. And so that CTE aspect, or any sort of now latent brain disease aspect of it, it's kind of well, it's everywhere. It's in the zeitgeist. But the flip side, I mean, you see how broad that spectrum was, right? CTE is not a disease, quote unquote. Right. CTE is in every brain. What causes it? So of all the uncertainty right now, to kind of let it ride and be everybody knows about this, it's fine. It's tough. But then what does your informed consent look like? Are you accepting and acknowledging that if you continue to participate and expose yourself to subconcussive blows, you could get CTE? I don't think the evidence supports that. So how do you document, from a lawyer perspective, how do you document that to capture it, to make sure you put the risk on the student athlete for continued participation, but also kind of land within what the general consensus is of the science?
One more online here. How are insurance companies adjusting the way they write policies or who they write policies for? And have you seen the policy holders changing their behaviors as a result?
I have not seen that. I haven't really ripped into that much. I would expect, and I don't know if that's from the NIL slides that we put up, or kind of the fact that these lawsuits could be trailing off 30, 40 years from now. I don't know what the question, specifically from, but I haven't really ripped into a good policy about like, how are we dealing with this and how are we covering this and what kind of tail coverage do we have? Because again, we're talking about 60s, 70s, 80s. There's doctors who are like probably sitting out there like, I don't know if I have 45-year tail coverage on what I was doing back, with the team.
I think we have time for one more from the room, or I have one here online.
Perfect. We vamped it out.
All right. Last one from online. Are you aware of cases that have successfully argued that concussion decades ago is now the cause of dementia in 70-year-old former college football?
Sounds like it was No, I'm not. I mean, the Onishko case is probably the closest one, which is, ALS. The research is still kind of being developed as like, exposure to concussive blows and like, what does that lead to with neurological decline and different diseases. But other than the Onishko case, I'm not too familiar with any cases. But I'm sure they're out there, right? Like those claims can be made and will be made.
All right. Well, Dylan and Kacie, thank you very much. Appreciate your time today and your expertise in this area. Thank you to all of our attendees in person and online. And we will see you again for another speaker series event.
Thank you for having us.
Yeah, thank you.
And thank you for all that you're doing.